Yes, please, my lord.
Suit number NICN/AK/03/2023 between Olumide Babalola LP to Olumide Babalola Esquire, claimants, and Attorney General of the Federation, defendant. The claimants took out an originating summons against the defendant on 30th January 2024, praying for the following. Just a moment.
Yes, my lord.
On 30th January 2023, praying for the following. A declaration that by virtue of Section 254(c)(2) of the Constitution of the Federal Republic of Nigeria, 1999, the Supplementary Act A/SA.1/01/10 on personal data protection within ECOWAS is an international convention enforceable in this honorable court without domestication by the defendant. 2, an injunction restraining the defendant and/or his agents interfering with the provisions of supplementary acts on personal data protection within ECOWAS in relation to employment and labor issues. 3, consequential orders as this honorable court may deem fit to make in the circumstance. The lone question for determination of the court is as follows. Whether or not by the interpretation of Section 254(c)(2) of the Constitution of the Federal Republic of Nigeria, 1999, the Supplementary Act on Personal Data Protection within ECOWAS is an international convention enforceable in this honorable court without domestication by the defendant. Claimant's affidavit in support. Yeah, I have produced the affidavit, almost the whole affidavit here. I may not take time to read the whole thing that I have produced here, but the affidavit was deposited by one Funmi Akindipe, female, adult Nigerian citizen. Is a litigation clerk of the first claimant in this suit. The cause of the litigation is that the Supplementary Act on Personal Data Protection within ECOWAS was ratified by Nigeria, but that Nigeria has not legislated on it. And the claimant, the second claimant, is a data practitioner. He earns from it. So with the refusal to domesticate, he wrote to the defendant to advise on whether or not the application of it, because he has clients who are skeptical about doing business in Nigeria because they don't know about the stance of the act that he wrote, requesting that the defendant should advise the National Assembly, and defendant had not responded. As a result, it is affecting his business because he is unable to advise his clients properly on the issue. That is the crux of the affidavit. The affidavit is long, but I reproduced the whole thing. From the particulars provided above, the claimants believe that's okay, that's still part of the affidavit. Claimant's written address. In his written address, Learned Etisang Solomon adopted the issue for determination and submitted that this suit borders on the provision of Section 254(c)(2) of 1999 Constitution vis-a-vis the application of ECOWAS Act that Section 254C2 of the 1999 Constitution has been interpreted in Sahara Energy Resources Limited versus Mrs. Olawumi Oyebola 2020 LPLR 51860 CA as empowering this court to apply international best practices in labor and convention treaties, recommendations, and protocols ratified by Nigeria, that the ECOWAS Act relates to labor and employment issues, citing Article 1 of the Act on definition of terms and submitted that employees qualify as data subjects. He concluded that the ECOWAS Act is contemplated under Section 254C2 of the 1999 Constitution. Defendants counter affidavit. The crux of the counter affidavit of the defendants is that no reasonable course of action is disclosed, that no dispute has arisen between the parties, that the claimant has failed woefully to establish any of his clients who had suffered or had his data right infringed, that the claimant's suit is premature and does not disclose any reasonable course of action, that the question for determination formulated by the claimant does not arise. Defendant written address. In his written address, Lanet Awoluyi Oluseun formulated three issues as follows. One, whether first claimant, not being a juristic person, can maintain action against the defendant. Two, whether the claimant's pleadings disclose any reasonable course of action against the defendant. C, whether the claimants are entitled to any relief sought in this suit. Learned counsel answered all the questions in the negative. Claimants reply on points of law. Learned Oladimeji, in the reply, argued that firms, partnerships, and business names can sue and be sued in their firms, partnership, or business names. Counsel relied on the cases of Answer and others versus owner-stroke managing director, RVL Motors, citations applied socio-political development versus Ministry of FCT and other citations applied medical merchandise versus Pfizer Incorporated and another citations applied Ataguba and Company versus Gura Nigeria Limited citations applied the Societal General Foundation Nigeria Limited versus Emol Nigeria Enterprises citations applied. On whether or not the suit discloses a reasonable course of action against the defendant, learned counsel submitted that the moment the legal rights of a claimant and the corresponding obligation of the defendant has been set out in the statement of claim, then a reasonable course of action has arisen. Court's decision. I have considered the question for determination. The relief sought, affidavits of the parties are written addresses of counsel. I am of the opinion that the issues for determination are one, whether the first claimant can sue and be sued. Two, whether this suit discloses any cause of action against the defendant. So in determining the issues, one, whether the first claimant can sue and be sued. The defendant has argued that the first claimant is a law firm, a registered business name, and so is not a juristic person and cannot sue and be sued, and so should be struck out. Claimant counsel relied on a plethora of decided cases and Order 13, Rule 22, and 26 of the 2017 rules of this court to argue the contrary. in George Obiamulu and Larry Ogbego. Sorry. Larry Ogbego citation is therein supplied. The Court of Appeal for Abubakar Sadiq Umar JCA stated the generally known principle of law thus. It is not in doubt that P.A. Oguche and Associates was registered as a business name with the Corporate Affairs Commission, CAC. See Exhibit CAT, page 97 of Record of Appeal. A registered business name has no legal personality separate from its owner or owners. Neither can it sue or be sued. Rather, it is the proprietor or proprietors of the business name that will sue or be sued. If the matter over which the action is instituted concerns the business name, it will simply be indicated that the proprietor is trading under the name and style of ABC business name. However, as the lower court rightly held at page 10 of the additional record of appeal, the case is still sustainable because the appellant's other attorney who sued on behalf of the appellant is as plaintiff at trial is a natural person who can validly institute this action. The above is but a general principle. The principle admits of exception. In Mr. Obina Amechi versus Rotec Automobiles and Estates Enterprises, the Court of Appeal for B. Gafai JCA held whether a business name can sue in its name or own property or interest in property had been a subject of divergent judicial pronouncements until fairly recently. As a general principle, only natural person and juristic person are competent to sue or be sued. Where a plaintiff is not a legal person, the action is liable to be struck out as incompetent. Section 37 of KAMA, Agbo Magbe Bank Limited versus General Manager, GB Olivant Limited, and another 1961 citation therein supplied. In 2005, however, the general principle was commendably expanded by the Supreme Court to admit of exceptions in Atugba and Co. versus Gura Nigeria Limited, 2005, 8 Nigerian Law Report, Part 927, page 429. The Supreme Court pointed out that there are exceptions to the general rule where the rules of court permit non-juristic persons to sue or be sued. In this connection, reference was made to Order 11, Rules 9 and 26 of the Kaduna State High Court Civil Procedure Rules 1987, which the Court of Appeal relied upon in holding that the appellant was properly sued in the name of his firm, Ataguba and Co. The provisions of Order 10, Rule 27 of the High Court of the Federal Capital Territory 2004, under which the suit in this appeal was litigated, provided in the same language as those in Order 11, Rule 26 of the Kaduna State High Court Civil Procedure rules. Flowing from the Supreme Court's analysis of the provisions of Order 11, Rule 9 and 26 of the Kaduna State High Court Civil Procedure rules, whose Rule 26 is exactly the same with that of Order 10, Rule 27 of the rules of the court below, it is thus beyond argument that the name by which the appellant in this appeal approached the court below is one that does not constitute any violence to the jurisdiction of the court below, as it is among the exceptions to the general rule that only natural or juristic persons can sue or be sued. Sorry, I'm having difficulty with the reading because the printer is faint. So I'm straining my eyes to read. Strangely, you could say I had to remove my eyeglass. That should rather help. I have read all the cases relied upon by the claimant's counsel and find them to be apt and applicable in this case. I have also read Order 13, Rule 32 and 26 of the 2017 rules of this court and find them to be similar with Order 11, Rule 9 and 26 of the Kaduna State High Court Procedure Rules 1987 and Order 10, Rule 27 of the High Court of the Federal Capital Territory 2004. And on the strength of the authority of Mr. Obina Amechi and Rotec Automobiles and Estate Enterprises and other citations supplied, I make no hesitation in holding that even though, as a general principle, only natural persons and juristic persons are competent to sue or be sued, where a plaintiff is not a legal person, the action is liable to be struck out as incompetent. There are exceptions to the general rule, where the rules of court permit non-juristic persons to sue or be sued. Order 13, Rule 22 and 26 of the 2017 rules of this court provides an exception under which the first claimant can sue and be sued in the circumstance as a law firm whose business is allegedly affected. This issue is accordingly resolved in favor of the claimants. Learned counsel, I didn't hear you.
Accomplices, my lord.
That is how we do it in court, so that we know that we are still together.
Accomplices, my lord.
2, whether this suit discloses any cause of action against the defendant. In Savage and others versus Uwecha, citation supplied. Fatai Williams, JSC, as he then was said, a cause of action is defined in Stroud's Judicial Dictionary as the entire set of circumstances giving rise to an enforceable claim. To our mind, it is, in effect, the fact or combination of facts which give rise to a right to sue, and it consists of 2 elements: the wrongful act of the defendant, which gives the plaintiff his cause of complaint, and the consequential damage. In Accord Party and others versus the Governor of Kwara State and other citations supplied, the Court of Appeal held. Now, Black's Law Dictionary, 7th edition. By Haven Gary, define cause of action at page 214 as a group a group of facts giving rise to one or more bases pursuing a factual situation that entitles one person to obtain a remedy in court from another person. For a cause of action to arise, there must be a right and a violation of a right, or there must be a disagreement or dispute that is justiciable in law. To begin with, the Constitution, Section 12.1 of the Constitution provides as follows. Section 12.1, no treaty between the Federation and any other country shall have the force of law except to the extent to which any such treaty has been enacted into law by the National Assembly. Section 254C2 of the Constitution, as relied upon by the claimant, confers exclusive jurisdiction on this court as follows. Notwithstanding anything to the contrary in the Constitution, the National Industrial Court shall have jurisdiction and power to deal with any matter connected or pertaining to the application of any international convention, treaty, or protocol of which Nigeria has ratified relating to labor, employment, workplace, industrial relations, or matters connected therewith. The implication of the above is that Section 254C2 supersedes the provision of Section 12 when it comes to application of international treaties relating to labor law in the NIC, because of the word notwithstanding anything to the contrary, which means Section 2542 will supersede Section 12. Now, this was the decision of the court in Mr. Peter Obi and Independent National Electoral Commission. Now, any matter in this section must relate to any question or dispute. You cannot have a matter to be litigated in court where there is no dispute, where there is no violation of a right. So the question for determination of the court as presented by the claimant is whether or not, by the interpretation of Section 254C2 of the Constitution of the Federal Republic of Nigeria 1999, the Supplementary Act on Personal Data Protection within ECOWAS is an international convention enforceable in this honorable court without domestication by the court, by the defendant. This question can only arise for determination if in this court, when there is a dispute between parties as to whether or not the Supplementary Act on Personal Data Protection within ECOWAS is an international convention enforceable in this honorable court without domestication by the defendant. There is no such dispute before this court. No practical situation as to the enforcement of the ECOWAS Act before this court has arisen, and so there are no live issues to be determined. This renders claimant's question on one for determination a mere academic, hypothetical, and speculative question. These academics and hypothesis or speculation is clearly demonstrated by the claimant's paragraph 9 of their affidavit, which is herein reproduced for ease of reference. Paragraph 9, 1 and 2 says, from the particulars provided above, the claimants believe that a resolution of the question for determination will, 1, avert any immediate or remote constitutional crisis on passing legislation on data protection in Nigeria, and this will personally and professionally benefit the claimants as privacy professionals. Further develop further develop the jurisprudence on data protection, and this will also personally and professionally benefit the claimants as lawyers and advisors. When it comes to academic questions or hypothetical questions, the courts have already held that it is an exercise for the classroom and not for the busy courtroom that deals with live issues or disputes. See Chubike Ibe and the Attorney General of Imo State, citations supplied where Abunda Gajesi held. It is settled law that courts do not indulge in wasteful and futile exercise by giving judgment in respect of academic hypothetical questions. Other authorities are cited therein. See also Alamo and another versus Pijao, citations applied where the court held courts are not set up to consider academic issues or points. Relief 1 reads as follows: a declaration that by virtue of Section 254C2 of the Constitution of the Federal Republic of Nigeria, the Supplementary Act A/SA.1/01/10 on personal data protection within ECOWAS is an international convention enforceable in this court without domestication by the defendant. I underlined without domestication by the defendant, because when I read that, the question that should agitate any lawyer's mind is whether the defendant, that is the Attorney General of the Federation, is the person responsible for domestication of any act. Well, it is also to be noted that the wordings of Relief 1 suggest that the defendant is the one responsible for legislation. The defendant does not domesticate or make laws. A dispute as to the domestication of the Supplementary Act on personal data protection within ECOWAS by the defendant cannot arise between the claimant and the defendant. That is a dispute for him and another person, not the defendant. Relief 2 is for an injunction as follows: an injunction restraining the defendant and or his agents interfering with the provision of Supplementary Act on personal data protection within ECOWAS in relation to employment and labor issues. I used to omit the A/SA.1/01/10 for ease of reference, but it's written there. If anything is to be deciphered from the complaint of the claimants, they complain about the refusal of the defendant to advise the federal government to domesticate the Supplementary Act on personal data protection within ECOWAS as requested in their letter, Exhibit 9. If the defendant has a legal duty to so act, to so advise, and he fails to do so, for which the claimants are aggrieved, the prayer should be one for an order of mandamus, compelling the performance of that public duty, and not one for an injunction forbidding interference with the act. Again, the defendant is not the National Assembly, so how can he interfere with the act remains in the realm of imagination. Going by prayer 2, the simple unanswered question is when and how or in what way is the defendant or his agents planning or attempting to interfere with the provisions of the Supplementary Act on personal data protection within ECOWAS in relation to employment and labor issues to the detriment of the claimants in the absence of any deposition as to the defendant planning or attempting to interfere with the provisions of the Act, there is no cause of action to warrant this prayer. For all the above, I find that the claimants have not disclosed any cause of action, let alone a reasonable cause of action against the defendant. This suit lacks merit and is accordingly dismissed. This is the judgment of the court, and it is entered accordingly. Each party to bear its cost.
As completed.
Claimant counsel, are you now in court? Claimant counsel.
Yes, my lord.
Announce your appearance. Announce your appearance.
Respectfully, my lord. Oh, Adeniyo.
Oh. You are.
Adeniyo, my lord. For the claimant counsel. Oh, Adeniyo, for the claimant, my lord.
I told you are for the claimant counsel. Yes, so Adeniyo, what do you say to the judgment?
Yes, my lord.
What do you say to the judgment?
Hello, we are most grateful for the work. We are most grateful for the work of that judges, my lord.
Yes.
We are most grateful, my lord.
Temilola.
Yes, my lord.
Temilola.
You never tell him.
Temilola. Well, a copy of the judgment will be ready for collection by tomorrow. Did you hear me, counsel?
I'm most grateful, my lord.
Thank you.
Yes, we are most grateful, my lord.
Yes, I said a copy of the judgment will be ready for collection by tomorrow.
Okay, my lord. We are most grateful, my lord.
You're welcome. AK 2022, Professor Kobio. Kobio,
my lord.
Kobio and Kobio Solomon
Victor.
And Wesley University.
May it please this honorable court.
Yes.
I'm Rashidat Akinrinde. My humble appearance, my lord, is for the claimant, sir.
Yes.
My lord, the matter today is slated for report of
the
settlement.
The defense counsel has still not appeared?
No, sir, they have not been appearing in this matter, sir. They didn't enter appearance, sir.
Really?
Yes, sir.
Yes.
My lord, the matter today is slated for report of settlement.
Yes.
The claimant reached out this morning that they reached out to him from the university that they are going to pay the outstanding balance of his claim this morning, which is 137,000.
First of all, let's confirm if he got the alert of the 500,000 for last adjourned date.
Yes, my lord. Yes, my lord. He got the alert that same day, sir. He received the alert that same day, sir. He told us, sir.
So the claimant also informed you
This morning, sir.
that the defendant
Yes, sir. Promised to pay the remaining balance this morning, sir. But he has not received the alerts yet.
to pay the balance of how much?
Of 137,396 naira 95 kobo, sir.
So what do you want?
My lord, we will most humbly be urging the court for a short adjournment, sir, so that we will come back to report to the courts if truly they paid today, sir. And then we take further, step in the matter, sir.
Necessary steps.
Yes, sir.
Yes, that.
My
was
lord,
like 2 weeks. Do you need 2
okay,
weeks
2
or
weeks.
4 weeks?
2 weeks is okay, my lord, sir, subject to the overriding convenience
Let's
of the
hope we
court.
have any chance within 2 weeks.
Okay, sir.
Okay, 22nd May.
As the court pleases, sir.
Case adjourned to 22nd May 2024 for further report of settlement. Defendants to be served hearing notice.
As the court pleases, we are most grateful, sir.
Thank you.
Yes, sir.
And that is the end of the Zoom hearing for this morning. We shall all leave.
Thank you, my lord.